Because if you've ever played a competitive sport in your life, you know how much easier it is to defend a play if you know what the play that's coming at you is. So what I want to spend some time with you today is to try to give you some sense of the law that applies to the kind of claims that we're all concerned about, the things that the bad guys will try to do to make a claim against you, and things that you can do now to try to get ahead of that. That is, to know the play that they're going to run and to try to be ahead of it on the other side. I can't tell you that any of the things that I'm going to do today will prevent you from getting sued. Anybody in this country can pretty much go file a lawsuit against anybody else for any reason, no matter how baseless or groundless. And there's nothing I'm going to tell you today that will stop you from getting sued. My standing joke with respect to this is the only thing I can tell you that will prevent you from getting sued is to go out of business and stop running your buses. But short of doing that and short of abandoning your business model, what I can do today is to, again, try to educate you on the type of things that we will see, the kind of claims that I am anticipating, and the things that you can do to get ahead of that. And let me start, before we actually get into our slides, to say that I think with respect to COVID-19, there are two things that you need to be primarily concerned about, really three things that you need to be primarily concerned about. First and paramount is the health and the safety of your employees and your customers. So regardless of what I'm going to tell you relative to claims, you need to be concerned about taking care of the people that work for you and taking care of the people that you otherwise service. We're all good people. I know you want to do that, and hopefully some of the things I'm going to tell you will make that a little easier. It just so happens that some of the things that I'm going to tell you relative to taking care of your people and taking care of your customers will also help you to take care of the other two instances or things that should be on your mind. The first is potential claims that could be made against you by employees, and those are arising here in Virginia, for example, as well as some of the other states that I service. There are people who are filing workers' compensation claims as a result of contracting the virus. And they're saying that as a result of being in the workplace, they contracted the virus, and that becomes a compensable injury that's covered by your workers' compensation insurance. Mercifully, at least from my perspective here in Virginia, the Comp Commission has denied every single one of those claims. That doesn't mean they're going to continue to deny them, and it doesn't mean that the Supreme Court has yet passed upon the propriety of denying them, but at least the Commission's view at this point is that the claims are not, in fact, compensable. In Virginia, as in several of the other states where folks who are operating at present may be on this call, the legislature is considering to specifically make those claims compensable. And if there's a lot of piece of advice I'm hoping I'm going to toss out to you that would be helpful. If that's happening in your state, and let me encourage you in the strongest terms to figure out whether or not that's going on in your state. It most assuredly is going on right now in downtown Richmond, where the General Assembly is considering, again, making it specifically a compensable injury. I would encourage you to pick up the phone and call your local delegate or your local senator, or to have the organization speak to the local politicians or the statewide politicians to contest that, because there's nothing good for us that comes up from employees having a reflexively compensable claim for compensation benefits if they contract COVID. So that's the first thing that you ought to be concerned about. The second thing that you need to be concerned about, and what most of this presentation is geared toward, is the idea of the extent of your liability if somebody contracts the virus or allegedly contracts the virus while on premises that you otherwise operate, including your motor coaches. Those are going to be, or have the potential to be, a big deal for the reasons that I'm otherwise going to talk to you about. So in that instance, that is the law of premises liability that lawyers typically deal with. That is the responsibility of the owner of a particular premises to make those premises reasonably safe for the people that otherwise come onto those premises for any number of reasons. And we can go ahead and start them up, Cindy. So that really generally is what I'm going to lay out for you, which is helping you understand just a little bit about what the law of premises liability is and how that law is going to apply in the context of potential COVID claims. So what is premises liability? Generally speaking, premises liability is the obligation of a landowner to make sure that the premises that it has for its business, that it otherwise uses for its business, whether that's a fixed workplace, like an office, or folks may get on a bus or get off a bus, or in fact the bus itself is reasonably safe for the people who otherwise are using it. I do a ton of work nationwide for Omni resorts and hotels. As a matter of fact, designated trial counsel for them in something like over 33 states. We see a ton of premises liability claims that arise at the Omni properties. And they come up in any number of ways. The most frequent way, and the way that people typically think about a premises liability claim, is in connection with a slip and fall. Somebody rounds the corner, comes into the men's room at one of our properties and slips and falls on water in the floor, and then wants to sue the property, claiming that the hotel didn't make the restroom safe for them to otherwise use, that the hotel is otherwise responsible for the injury and the damages that flowed therefrom. It's going to include you. It doesn't have to be a fixed workplace. Premises liability law most assuredly is going to apply to the operating of motor coaches. And we know that because, number one, it just does. And number two, there are arguments being made all across the United States today relative to the cruise line industry, the airline industry, Amtrak. These are all people that are starting to face claims from patrons who say that they have contracted the virus while using one of those forms of mass transportation. So again, the types that we typically see, the types of incidents that we typically see arising in the premises liability, slip and falls in grocery stores. I get a lot of injuries around pool decks. In your particular case, the kind of typical premises liability case I would expect to see would usually be something that involved broken steps, loose steps on the bus, a door that didn't work, a seat that was broken, maybe water in the restroom on your coaches, a driver doing something, closing the door on a passenger, or certainly a driver doing something that otherwise caused an accident. Those would be the typical type of premises liability cases that we usually would see. And in the typical liability, for a premises liability case, we would expect to raise one of any number of defenses. And the first and most effective defense relative to any of those claims is that we didn't have notice of whatever the dangerous condition was. There are two types of notice, and without getting too technical, the owner of premises can be charged with actual notice of a defective condition or constructive notice of a defective condition. The latter being a condition that's existed for such a period of time that whoever owned the premises otherwise should have known about it. So if you have for example, in the usual situation, premises liability situation regarding the operation of a motor coach, if somebody claimed that they sat in a seat that malfunctioned, caused them to be thrown backwards, fell out, hurt themselves, then the question to you would ordinarily be, did you know that there was a problem with that seat, or should you have known there's a problem with that seat? As defense attorneys, we almost always take the position that absent some kind of documentary evidence to the contrary, that we had no notice of what the condition was. The second defense that's almost always available to us in these cases is that the claimant cannot have been contributorily negligent. That is, in any case where somebody makes a claim against you in the states that recognize contributory negligence, you can raise as a defense the actions of that person. So if somebody's walking up the steps of a bus and you've got a little note on the side that said this step is slightly bent or slightly broken, even though there may be an obligation on you to have the step in decent condition, if you had warned about the condition or otherwise somebody said something to them about the condition and the person who was making the claim had ignored that admonition, then you'd be in a position to say that they had caused or contributed to cause the happening of an accident. That is also a defense. There's a third defense that will be particularly pertinent to what we're talking about here today, which is the assumption of the risk defense. If somebody's going to engage in an activity, particularly an activity that's offered by a commercial enterprise, and that commercial enterprise says to them, hey, this is dangerous, it involves certain risks, these are the risks, are you sure you want to do it? And then the patron decides that after having been fully advised of the risk, that they voluntarily, knowingly, and willingly want to participate in the activity, and then they get hurt, then there's a defense to say that they had assumed the risk of the activity. For any of you that's ever been, like I have, bungee jumping or have ever done any zip lining, ever been horseback riding at any resort, they give you this release that's longer than your right arm to read and sign. The express purpose of that is to say that you were advised of the risk and you chose to take the risk, and now you can't sue us if you otherwise get hurt. That usually implicates, as I just said, a liability waiver, which I'm going to talk about in a little greater detail in just a couple of minutes. what are the cases about? And one of the things that I can tell you, two great lessons that I have learned as a lawyer over the years. The first one, which was one of the most disheartening things that I learned after about 6 months, was that people will lie. They will raise their right hand to God and swear to tell the truth, and then turn around and look you right in the face and tell you an abject lie about something. I've cases, a myriad of cases over the years where I've got video of exactly what happened, 5 eyewitness accounts and a written statement by the claimant, yet they'll sit in a deposition and tell me a completely different story. Which, again, as a young lawyer, was fairly disillusioning. Now I'm just used to it. And the reason they do that is what you see on the screen right now, which is dollars. Regrettably, after, again, 33 years of doing this, I've come to the conclusion there's not much that people won't do or say if they think that there's money in it for them on the other side. And that money, to be clear, that they are looking for in these type of claims is yours. Or even if it nominally belongs to your insurance carrier, it's ultimately going to be yours, even in the form of a deductible that you may have to pay, or a self-insured retention that you may have in front of your coverage, or what your premiums go up by as a result of having a claims history. So make no mistake about it, these cases are all about money. So what in a typical premises liability case, how does a claimant typically come after us with respect to those claims? Well, the first thing they want to show is that there was some kind of dangerous condition that existed, and whatever the premises were, again, fixed premises, or in your case, a motor coach, and that they were injured as a result of the same. That they're going to have to prove 4 distinct things. That's, to be honest with you, sound a lot harder to do than what they really are. The first thing they're going to need to prove is that there was a duty, and there will always be a duty on anyone that operates a commercial enterprise to the people that otherwise come on the property of that enterprise. And the duty is, generally speaking, the duty of the landowner or the person operating the commercial enterprise to make the property onto which the patrons come reasonably safe, to exercise ordinary care to make the property reasonably safe. So ordinary care, which is a concept that was developed by lawyers for lawyers over the years, is what a jury believes it is. What might be ordinary care to you may be not nearly enough for me, and nowhere near enough for the folks that sit out and work in other parts of my office. What is ordinary care, and whether or not you have discharged the duty that's imposed upon you, almost always will be a jury question. So the claimant will establish that there was a duty, that you owed them a duty, and then will seek to establish that you breached that duty. That is, that you didn't do something that you should have done, or you did something that you shouldn't have done. That there's a duty, for example, a very simple, straightforward duty, not to let the floors where you expect your patrons on your buses to walk to be encumbered with liquid spills or a bunch of trash or things that otherwise in the walkway. That's the duty. If you don't clean that up, you've breached that duty, in simplest terms. The type of duty that you owe to people is going to vary depending upon what status the person has who comes onto your property. So if you operate a commercial enterprise and you have a trespasser that breaks in through the back gate and tries to get into one of your buses, you owe them very little duty. The law recognizes there's very little duty owed to a trespasser. As a matter of fact, about the only duty owed to a trespasser is, generally speaking, not to intentionally inflict harm upon them. The second kind of person that can come onto your property is what's called a licensee. That's a social guest, not somebody there to do business, but somebody that stops by to say hello. You've got an obligation to exercise ordinary care to keep your premises in reasonably safe condition for any licensee. The highest duty that the law imposes, whether it's Virginia or anywhere else, is to somebody who is a business invitee, someone who has been specifically, either by implication or express invitation, invited to come on your premises for purposes of conducting business with you. Those people are owed the highest duty. The people who are going to get on your motor coaches are owed the highest duty under the law. You need to be reasonably inspecting for anything that could be a hazardous condition and alerting anybody that comes onto your premises to any condition that you know about or that you should have known about. They get the highest duty. Told you they'll show that there was a duty, they'll show there was a breach. Then to continue to make the claim, they need to show that the breach of the duty caused their injury. Again, using the example, we've got water in the floorboard of a bus or trash in the floorboard of a bus. That's violent of the duty. You don't clean it up, that's the breach. If they walk through and slip and slide and fall on something, then they're going to be able to show that the breach of the duty was a causative factor of the fourth element they need to demonstrate, which is their injury and damages. Think about damages as the stuff that you're talked about on TV all the time. It's the medical expenses, the lost wages, out of pocket, and also the ubiquitous pain, suffering, anguish, all the other things that are difficult to quantify. Those are the four elements that are typically involved in the proof of any premises liability case. So how will that apply to COVID? And let's, I try not to be somebody who spreads bad news, but I'm not telling you anything that you otherwise don't know about COVID. The earliest estimates I have seen relative to having a truly effective therapeutic is within the next month or two, and maybe at the end of this year having some type of vaccine that may be widely available, although the projections I have seen suggest it's going to be the first part of next year at the earliest. And even once we have it, we probably are looking at an effective vaccine of maybe 60 to 70% if it's extraordinarily effective. So it's not going anywhere anytime soon. And you can tell, again, we just pulled up the numbers from Virginia. The one constant with respect to all the states that are charting numbers is that the number of cases continues to go up. The number of hospitalizations continue to go up. The number of deaths continue to go up. If you're operating a commercial enterprise, you will not now, nor will you ever be able to claim ignorance of the idea that COVID was a problem to be addressed and to be dealt with, and something that should have been taken very, very seriously. So what will be the case? What's the play that you're going to see run against you if somebody wants to make a claim against the company that you otherwise operate for having contracted the virus? Well, the first thing they're going to look to establish is what the duty was. Remember, duty, breach, causation, damage. So what's your duty? The duty that's going to arise in this case can come from any number of a myriad of potential options. Because there are a lot of places out there right now that are saying a bunch of things, some of them similar, some of them dissimilar, about what you need to be doing relative to protecting the premises that you're operating for both your employees and the general public. The CDC has got guidelines that they articulate. You haven't read them? You should. If you don't know what they say, you should if you're going to operate a commercial enterprise, because they talk about things that you can do to reduce, maintain, consider, and discourage. Being familiar with those is going to be important. Understanding that that's where the bad guys, that's where the plaintiffs, the reason you need to be familiar with them so you can live by them, but understanding that the claimant's lawyers will use those as setting up the standard pursuant to which you should have followed, the things that you should have done. So knowing what I've just told you, if you know that's one of the standards they're going to set up, and there's daylight between what the guidelines say and what you're doing, then ostensibly you have a breach of the duty. That's not the only place they're going to be able to find a duty. You can go ahead and get past that. The OSHA articulates a general standard out there that's relative specifically to employees, but claimants' lawyers will try to establish another level of duty, because it's a standard. The OSHA standard basically has a general clause that says they have to provide, that you have to provide a workplace that's free from recognizable hazards which can cause injury or cause death or serious injury. That will be a standard that's available to the claimant's lawyers to use. Each of you have operated in states where there is a state Department of Health, some more active than others. But in Virginia, for example, our Department of Health and our governor has been very active in articulating standards with respect to what you have to do relative to the operating of commercial enterprise. They talk about things like physical distancing, enhanced cleaning, disinfection, and enhanced workplace safety. So the same thing as with CDC. If you don't know what your Department of Health has said, you need to educate yourself, because that will be a standard, that will be a way that a claimant's lawyer would attempt to establish a duty that was imposed upon you. Virginia standard, I would humbly suggest to you, at the time it was articulated, it was trumpeted as being the first statewide standard that had been promulgated by any of the states relative to enhancing workplace safety. And the things that an employer needs to do in Virginia are fairly onerous, and they are fairly complex, and they are fairly complicated. It requires doing things like workplace assessments and developing and implementing policies. And what are you going to do if somebody gets sick? And if somebody gets sick, what kind of tests do they have to have on the other side? There's a whole litany of things that you have to do. And not only do you need to do them, you need to be in a position to document what you did. All these things that I'm talking to you about relative to becoming potential duties, you need to think about what would your files show that you did as you tried to educate yourself on what the duty was, and what would your files show that you did to demonstrate that you tried to live by what it was that you understood to be the duty. Again, more things here from the Virginia, the things that the Department of Health want or Department of Labor want. It's a fairly onerous standard that's been articulated in the Commonwealth. So those are the kind of things that are going to be set up as the duty. What things do you need to be thinking about that you need to do? I give, again, the different version of this comment every time I talk to people, because I understand as a guy that operates a business that there are budgetary constraints, financial constraints on any number of things. In the world we live in, the negligence-based world where claims like this are made that we live in, there will always be something else you could have done, always. If you could spend your way to absolute safety, then the people that operate, Microsoft, people that operate the huge trucking companies like Swift, Knight that I otherwise represent, if you could spend your way to absolute safety, they'd never have claims made against them. You can't. But what you can do is try to reach a balance within the operating of your business between what you understand the risk to be, and then figure out what you can live with relative to mitigating that risk. Here are some easy things that you can look at relative to mitigating that risk. I would tell you, and I think because I do all these things, and I encourage everybody that I talk to do all these things relative to the concept of the duty that you otherwise are going to be under. We stop everybody at the door on the way in, whether they are employees or whether they are vendors, whether it's the local sheriff coming to serve me process for one of my clients, whether it's the FedEx man, the UPS man, it doesn't matter. If you're going to step a foot inside my building, then I'm going to take your temperature. And the temperature reader that we have is set up to a certain point that if you're okay, it blinks green. If you're not okay, it blinks red. If it blinks red, you don't come in. It's just that easy. If anybody comes on property that is something other than one of my employees, then they are going to have to fill out a form certifying, in addition to the temperature check, that they haven't had any COVID symptoms within the last 7 to 14 days. Any customers and this would be specific to you because most of the guys I deal with are on the phone, but I really encourage everybody who can get a liability waiver to get a liability waiver. And again, I'll talk about that in a little detail in a moment. And then the other thing I think you need to make sure that you've done both relative to compliance with OSHA regulations as well as inoculating yourself against potential third-party claims is put some signs up. Put some signs up on the front of your door about if you're going to come inside, you got to have your temperature taken. If you're going to come inside, you got to wear a mask. If you're going to come inside, you have to certify that you haven't been sick. Saw signs up around your office saying if you have symptoms or you have problems, you need to report it. Thinking through the protocols that you're going to implement and making sure that you've got them in place. What has your thought process been if somebody reports they're sick? How are you going to handle that? Are you going to send them home immediately? Or how long are you going to keep them home for? I'd tell you send them home immediately. What's the protocol going to be for what is the circumstance in which you're going to allow them to come back to work? Are you going to have a symptom-free strategy where if they're symptom-free for 14 days, you let them come back? Are you going to require them to have a test to come back? Some people are requiring 2 tests, 2 negative tests before employees come back. What's your protocol? Have you thought through what you're going to do with respect to telling other employees that somebody in your office has reported being sick? I would suggest to you, you need to do that now and get something in place where you can alert everybody that has been in any contact with that employee about any employee that otherwise has shown symptoms of the injury. Those are all simple things that you can think through and start to do at this point. I would be very aggressive on making sure that employees who are showing any symptoms are told to stay home, that if to the extent your business allows it, that you have flexible work policies so that folks can come home or go home or work from home if they need to, and that you are reminding people of the things that we all learned in the 3rd grade. Cover your mouth when you cough, make sure there's plenty of soap around, and make sure there's plenty of hand sanitizer around, and tell people to use it. Why do you do all this stuff? Why? Let me tell you why. If you have a claim, like any claim that we otherwise defend, there are always 2 things that become very important relative to defending a company. Very, very important. The first thing is what I call the good company story. That is, are you operating your business in a way that's going to allow me or whoever your lawyer is to stand up wherever we are in court and to tell the story that you're a good company, that you try to do things the right way, that you care about your employees, that you care about safety, that you're engaged in suitable policies with respect to who you hire, who you retain, and that you have appropriate disciplinary policies in effect, and that you have appropriate training policies in effect. Those become big deals. And if I'm talking to you about things that you don't have in place right now, you're not thinking about right now, you ought to, because the defense of any corporate client starts with being able to say that you're a good company. I always tell people as well that not only do you want to have all that stuff internally, but you also ought to think about what your public persona is. What can the public see about you relative to the potential defense of any liability case? In 33 years of trying literally hundreds and hundreds of cases in front of juries across the United States, I hear the judges say the same thing every time to every jury at some point. You're supposed to not look at anything or consult anything outside of what you hear in this courtroom. You're not supposed to talk to anybody or look at anything. It never works that way. I promise you folks, as soon as jurors go home for the evening and start talking to their husband, their wife, and the children, somebody's going to pick up a phone and somebody is going to Google whatever the company is and whoever the company representative is to see what there is to be seen. So note to self, if you don't have a website, I usually encourage people to have a website, and I also usually encourage people to use a website as an opportunity to put the most positive public persona out there that they possibly can. Little things that may not be directly related to COVID, but the advice I try to share with everybody. Every safety award that you win, every public recognition that you get, everything that you have done that sounds good, looks good, feels good, it needs to be on your website somewhere, because that is helpful and when jurors do look at it to shape a very positive public persona of you. Enter every safety contest that's available to you, whether through any statewide association or through your insurance carrier. And if you get 7th runner-up, Mr. Congeniality for it, that's fine. Put it on there. The other thing I always tell people to do that is a low-cost kind of insurance policy is do something that you can project that demonstrates that you are a good corporate citizen. Write that $100 check to the Petersburg Little League. Write that $50 check to the American Cancer Society and put somewhere on your website that you're a proud supporter of Little League Baseball. You're a proud supporter of the American Heart Association. You're a proud support, whatever you're a proud supporter of, put it on there. That kind of stuff matters when juries are looking at you. The other kind of thing that matters outside the general feel-good stuff that you can broadcast and get ahead of, what are you doing? What are the decisions that you're making relative to any particular incident going to look like? And again, without focusing necessarily on COVID, on any case that I have where we're defending a liability case, the following things always come under scrutiny. What are the circumstances and the criteria that you use relative to hiring employees? What are the circumstances and criteria that you use relative to the retention of employees? What kind of policies and procedures do you have in place relative to the training of employees? And what does your maintenance, inspection, repair protocols look like? every case that I have that involves a casualty claim are going to involve those things. You may not have all of those with respect to COVID, but what you're going to have with respect to COVID is all those things that I just mentioned to you. You're going to have an analysis, and the guys on the other side who are going to want to know, what did you do to take it seriously? What did you do to educate yourself? After educating yourself, what did you do to make sure that the people in your shop were compliant with whatever the particular standards were? What did you do to enforce compliance? What did you do to stay abreast of any new developments? Those are all things that are going to matter because you've got to hear it the way a jury is going to hear it. And you've got to think when you're anticipating these claims and getting yourself positioned so that a guy like me can stand up and say, let me tell you what we did. Let me tell you how we approached this. We got on this right from get-go. We did A, B, C, and D. We were trying to do the best that we could possibly do, and we got a good story to tell. So again, what you're going to see is they're going to point at all these guidelines that I've otherwise mentioned to you, and they're going to say that that sets up the standard, that articulates the duty. So you need to be familiar with what those are. The other thing I would tell you that you ought to keep your eye on is, in addition to looking at what the CDC says and what OSHA says, and looking at what you might get from your state health departments, they're going to look to see what other folks in the industry were doing. They're going to want to see what other motor coach companies were doing, from the very big carriers to the smallest carrier. So being generally aware of what I call the state of the art in the industry is a good thing. And while, again, I'm not going to tell you that you've got to be at the top of the food chain with respect to the state of the art, but if you're going to be different from what it is that the biggest and most well-financed carriers are doing, then there better be a good reason for it other than it simply costs too much, because that never plays well before a jury. I hear a lot of times, somebody actually made the comment at the beginning of this meeting about how will anybody ever be able to prove that they contracted the virus on a motor coach that we operated? And this is one of those other disillusioning things that you figure out as a lawyer. I promise you, as sure as tomorrow's Thursday, my name's Steve, and this is a hardwood table, that they won't have a problem going into the world and finding a, quote, expert who will say that I've talked to the claimant, I've done an assessment of where they were and what they did. And it's my opinion, to a reasonable degree of scientific certainty, that it's more likely than not that they contracted the virus on the motor coach. So even though you may have stopped 5 places, did 25 different things, they're going to look to the entity what they think has a deep pocket, or at least a pocket of insurance that is capable of paying. That is particularly the case if you have any outbreak of virus on any of your buses that's documentable, or worst case scenario, you have an outbreak of virus on any of your buses and you didn't follow the various standards. Then you've made yourself a big fat target relative to these type of cases. It's not genius on my part figuring it out. This is what we're already seeing. The cruise line, as I said, has had a multitude of suits against the airline industry. Gyms, health clubs have had a bunch of them as well, and Amtrak is starting to see some suits as well. There are experts out there who are advertising this very service. We'll take a look at your claim. We understand you got sick. We'll take a look at where you went, what you did, and we'll offer you an opinion about where it's most likely that you contracted the virus, which in English means you pay me and I'll look around to see whoever we think has got the deepest pocket insurance carriers, and that's who we'll make the claim against, and I'll provide the testimony you need to make that claim. The defenses, so knowing that's the playbook, those are the things you're going to do. What are the defenses that we want to get ourselves positioned for now? This is where I want to talk to you about liability waivers. I know different people think different things about them, and there's something you should understand about them. Not every state gives you a get out of jail free card simply because you have a liability waiver that is executed. Virginia, for example, doesn't. You cannot sign a liability waiver in Virginia and reflexively protect or have protection for any injury that that patron sustains while engaged in the activity covered by the waiver. You just can't do it. It's unconscionable. It's contrary to public policy. They don't want people bringing people in, having signed liability waivers, then not really taking the appropriate steps necessary to make an activity safe. So if you decide you want to go zip lining at the Omni Homestead and you sign a liability waiver, the Omni doesn't get to go to court and automatically say, we win. They signed the waiver. It doesn't work like that. But what it does do in Virginia is, and places where that happens to be the law, is if your waiver is appropriately crafted, and the devil is always in the details on that, that if your waiver does a good enough job of setting out, this is who the participant is, this is exactly what the activity is going to be, these are the precise risks that are involved in the activity, I'm providing them with answering any questions they have about the risk. They've had ample opportunity to ask questions. They've had ample opportunity to decline to participate. They're signing it voluntarily after having read the whole thing. If they want to go get counsel, to go over it with them, they certainly can. There's no pressure here. If you do those things in your waiver, then even though the waiver may not operate to preclude the case reflexively, what the waiver will do is allow you to raise the assumption of the risk defense, because that becomes a written embodiment of every element of the assumption of the risk defense that I told you about earlier. You remember the defense where I told you that you can always say that somebody knew the risk and they assumed them? Well, that defense will get raised at minimum if you have an appropriately crafted waiver. There's also a possibility in some of these cases that we'd be able to say, if somebody claims they got sick on one of your buses, that we'd be able to say that we had no notice of any dangerous condition that existed on the bus. To be able to raise that defense, though, we're going to need to have some idea that none of the patrons that we otherwise service were sick, and that there's no evidence of any presence of disease on the bus. So that implicates making sure we have appropriate cleaning procedures, that we're taking the temperatures of people that otherwise ride. We're getting people to certify they haven't been sick. We're getting employees to certify that we haven't been sick. We do that, we probably got lack of notice defense. And then certainly contrib, if, you know, in any of these cases that we ended up defending, I would want to know, and we would go after vigorously, any evidence to establish that any of the places that the patron who subsequently became sick had been, that there was virus presence there, and maybe that would constitute some kind of defense of contributory negligence. This is, and let me say, I should yell this part, this is some sample language for a waiver. I would encourage you, don't just roll this out and think that you otherwise are covered. Waiver language and the enforceability of waiver language is specific to the jurisdictions where you operate. The laws of each state otherwise apply. This is simply a template, a sample to give you an idea of what some of the things that probably should be included in your waiver should be. There are a multitude of other things that would go in there, and depending on where you operate, there's some things that may otherwise come out. The takeaway for you as you look at this slide is, I need one. I got to have one. It needs to be compliant with the state where we otherwise are operating. Motor coach industry is not alone in requiring waivers. I've done waivers for, I didn't do the one for University of New Hampshire. University of New Hampshire has its own legal team, but they are using waivers before students are allowed back on campus up there. Hair salons are using them, dentist offices are using them, and we have been participating in the crafting of the waivers that our other good client, Gold's Gym, otherwise rolls out for its employees. Folks are using them. They will be enforced to the extent consistent with the law. If you've enjoyed listening to me and do absolutely nothing of what I've said today, then you're increasing your chances of ending up here. Linda heard me use my favorite analogy the other day. If you're going to operate a commercial enterprise, whatever that is, you are deciding, making a conscious decision that you're going to play Russian roulette. You cannot guarantee that your number is not going to come up and you're not going to get your head blown off with respect to some type of casualty incident. The best you can hope to do is to control the number of bullets that go in the gun. And the way you do that is to exercise as much care as you can, to be as careful as you can, to make it less likely that you're going to get sued. can't guarantee that you're not going to get sued. And I see some frustrating circumstances over the time where the people who spend the most money and do take every precautionary step they can take still have catastrophic events and still get claims made against them. I also see people who I don't know how the hell they've been in business for more than 2 weeks, but they'll operate for 20 years and never have an event. Neither of those are the way to bet. The way to bet is to do the things that you need to do to try to stay ahead of the curve. Or in this case, the wave, because the wave is coming. We're probably now, this is a little dated, I think about a week and a half old. We are probably north of 5,000 lawsuits now that have been filed across the United States that involve claims of premises liability related to exposure to COVID. Most of them, as you would expect, or the majority of them, I should say, are nursing home cases, but that's not all of them. It's airlines, cruise lines, fitness chains, entertainment industry, anybody where people go places and do things, they're getting sued. Another young man mentioned early on that whatever state he's operating in, some states have decided to grant immunity, at least partial immunity for this. This is the short list of the ones that I know about as of today. Virginia has legislation proposed, I wouldn't say pending, to grant immunity, but the immunity is not absolute. There has been some consideration of the federal government granting immunity, but the guys in Washington can't agree on what time it is. So I wouldn't hold my breath to believe that we're going to get any relief from this Congress relative to operating any business and expecting there being some kind of commercial business immunity. You can go ahead to the next one. We know that the lawsuits are here. A couple of plaintiffs' attorneys were quoted in the Wall Street Journal just a few weeks ago saying that they view this as a 100 billion with a B jackpot. And some pretty big names are being sued right now. Walmart, Safeway, Tyson's Food, a lot of folks who are getting hit with lawsuits by either employees or patrons who claim that the premises weren't reasonably safe. So I've told you some basic stuff to do, and now let me put a point on it. First, the first thing you got to do is check your insurance policies. Make sure that if and to the extent that these were deemed to be compensable claims by your employees, that your comp insurance would cover it. I'm 99.9% sure that that's going to be the case for everybody. But you need to check your insurance policies relative to claims made by third parties, that is patrons for whom you operate the motor coach. You would be surprised how many policies have a virus exclusion in them. So you need to make sure that your policy doesn't have a virus exclusion. Why do you do that? Well, for the simple reason that if a claim is made against you, your insurance stands in front of you to pay up to the limits of the policy that you have in place. If you ain't got any insurance, then it's no policy to pay, and the first dollar with respect to paying lawyers to defend your claim or paying any settlement or judgment, if any, comes out of your pocket. Talk to your insurance agent, your broker, and make sure you've got coverage. Second, identify, that is name, tap, pull out of the line, volunteer, whatever verb you want to attach to it, a workplace coordinator who, as part of their job, is responsible for COVID-19, the issues, and knowing what the guidelines are and compliance with the same. I promise you as I sit, live, and breathe, if you have one of these cases that proceeds to a lawsuit, there will come a time when some smart alecky lawyer on the other side of the table is going to look at you or whoever's testifying on behalf of your company and say, okay, tell me who your workplace coordinator or whoever it was at your shop was who was tasked with the specific responsibility of being up to date on the regulations and seeing to it that the regulations otherwise were enforced and complied with. And tell me what they did. How often did they work? What did they do? How frequently did they check for updates? What did they do to make sure that they were staying abreast of that? What were their qualifications to serve in this role? Those are the kind of questions that you're going to get. I would say, at minimum, in addition to tapping someone to serve in that capacity, I would make sure that they had a calendar reminder set up on a weekly basis to check at least the 3 websites that I have told you about, namely the CDC, the State Department of Health, and OSHA to see if there's any change in what the suggested requirements are, because God knows, as we have all waded through this, we have seen the suggestions and requirements and the best practices change. So we need to not only have the coordinator, that coordinator needs to be checking on a weekly basis. I would tell that coordinator to also, if and to the extent there are alerts, I know, for example, you can sign up to get alerts from the CDC whenever they change something, or alerts from the Department of Health whenever they change something. I would most assuredly sign up for those and make sure those alerts were coming. Excuse me. And I can't remember if this is on a subsequent slide or not, so I'll say it now so I don't forget it. In addition to having that coordinator be aware of what the standards are, in addition to having that coordinator being kept up to date on what the standards are, that coordinator needs to be responsible for compliance. Compliance really is a total business task. We all are responsible for each other to some extent on that. Everybody in the office should be reminded to remind everybody else to wash their hands and to use hand sanitizer and to wear their mask in common areas or public areas and to socially distance. But somebody's got to be the drill sergeant on that. And somebody needs to make sure that they are acting as drill sergeant and are with some frequency either walking the premises or talking to employees to see to it that the guidelines or whatever your particular internal policies are being enforced. That includes social distancing. And what I say I'll tell you how our coordinator does it. Our coordinator, who happens to be my firm administrator and who missed her calling to be a Marine Corps drill sergeant, that's what she should have been. She walks the halls, and if you don't have your mask on in about 2 seconds, you wish you did, because she makes a point of verbally alerting you. That's code for yelling. But she'll verbally alert you that you don't have your mask on and you need to put it on now. She also has been empowered and authorized by me that if the problem children around here don't pay attention to that and in short order are found not wearing their mask again or not appropriately social distancing, they get a written warning from me that goes into their personnel file. And if that doesn't make the case, then I send them home for a day. It's a shame that grown people have to be treated that way, but the reason you do that is ostensibly to help keep them safe, keep the other employees safe, but it also has the very profound effect of if we're sitting in a deposition defending one of these cases and somebody says, oh, okay, so you had a workplace coordinator who was tasked up with making sure everybody followed the rules. Did you ever discipline anybody for following the rules, for not following the rules? Well, no, not really. So you're telling me 100% of the time that every single rule that you guys articulated was followed by everybody? Well, no, not really. Now you're in a trap. Now you got a problem. Now it looks like all you did was designate a coordinator for the express purpose of checking a box because some Richmond lawyer told you so, but you really didn't care about whether or not that was the case. So you have got to live what you preach and empower somebody to enforce the rules, including the discipline that may follow from that. Again, the good hygiene stuff we've talked about a little bit. I will tell you that I think, I don't know how you handle the cleaning of your coaches. I'm sure it varies from company to company. I don't know how you handle the cleaning of your workplaces if you have paid staff or maid service, janitorial service, excuse me, that comes in and does that. During this time, there needs to be something extra added. You know, for example, here in our office, and I'll just pick our office as a fixed workspace, we have janitorial service on a nightly basis. They come in. Well, since the pandemic came in, we have added some additional disinfectants for them to use on all the hard surfaces, all the touch surfaces. We've also added that they make sure they wipe down all the doorknobs and the handles and things that people touch during the day. Something that starts to meet the definition of an enhanced or a deep cleaning. Again, opinions vary about whether that stuff matters. I mean, we have seen descriptions from the CDC say that, you know, the virus only survives on hard surfaces for just nanoseconds. Maybe it does, maybe it doesn't. I don't know. What I do know is if somebody comes back and tries to sue me for saying that they contracted the virus here, I want to be able to turn around and point to my janitorial service and say, well, tell them what we did. We pumped up the amount of cleaning and the level of cleaning and the attention to detail that we otherwise use. It's just good defensive medicine. Same thing for your coaches. Don't find yourself in the position where you're doing the same cleaning and sanitation of the coaches now as you were doing before the pandemic. If you're doing that, imagine the line of question that you invite during the course of deposition. You knew about this worldwide pandemic. You knew it had killed almost 200,000 Americans. You knew it had killed almost 6 million people in your state. You continue to operate this. You used to clean your motor coach this way. You didn't make any change to it to account for the increased risk that you so clearly acknowledged in the course of deposition. Don't put yourself there. Add something. Do something different, whether it's in the amount of time you clean, the depth to which you clean, or the things that you clean. You need to be able to say, relative to putting our best face forward for claims ever made, that you had an enhanced cleaning procedure in contemplation of the pandemic. And these are all things that are fairly self-evident. I'm hoping that everybody's doing about minimizing face-to-face contact. I do think it's important. And again, as you read these things, keep in mind, these things are helpful to keep your employees and you safe. They also sound really good if we have to go to court and defend one of these claims. So making sure that you would be in a position to say, I educated my employees. We had policies in place about what to do when you're sick. We had policies in place about circumstances under which you could return to work, and we lived those things. That's the good company that I need to be able to talk about. Follow the guidelines. So that's a lot. I can tell you that I wish there was a silver bullet that was the answer to everybody's questions that made all this go away. God knows the damage to the United States economy, the world economy, has been profound. And we will see on the other side of this, people, dirty, lousy lawyers, candidly, who are going to try to capitalize on everybody else's heartache and make $1 off of this. Get yourself in the best position that you can afford to be in, that allows you to sleep at night, consistent with your insurance coverage, so that we can say, this is a good company, we did things the right way. If you do those things, then you optimize our ability to defend against those claims. That's a lot, and there may be questions, and if anybody has anything, I'm happy to answer or take a shot at answering anything that you got.
I've got a question. Linda, if I can, you were talking about allowing people to come into your business and you check their temperatures. So on the bus side, is that going to be something that we would be okay with doing as far as checking temperatures of the passengers before they get on a motor coach? Would that be, or getting them to sign a waiver that if you get on this coach and you catch COVID-19, we're not responsible? Is that something that you think is reasonable that motor coach companies can do, and delegating that to the driver? I think that's, I don't know. I'm just throwing that out there for you to.
Yeah. So listen, I understand the 8,743 reasons you wouldn't want to do that. I really do. I mean, it is a logistical nightmare. You invariably are going to have people that don't want to have their temperature taken. You're going to have protocols and things in place that what are you going to do when a family of 4 shows up and the mom's got a temperature that's elevated and the other 3 don't? But I would suggest to you that the alternatives to that are more of a headache, because the alternatives to that are you don't test, you don't get waivers, you put folks that you don't know are sick or not onto one of your buses, and then suddenly you have a super spreader event where you have 15 people who were in contact with somebody who in fact had it on one of your buses, and then they all turn around and say to you, what did you do to make the bus reasonably safe before you let us on it, right? If you don't get those waivers, if you don't get something that gives you some ability to say, look, this is an activity that carries some risk to it. We're going to get on buses. We'll be socially distanced to some extent, but we have typically one restroom that we're going to use. We're going to be in fairly close proximity. Then I think you run a risk. Some people decide to run that risk. American Airlines runs that risk every day. They aren't, at least I don't believe American is. I saw the other day one of the major carriers is starting to take temperatures, and I know at least one of the other major carriers is starting to make passengers self-certify before they get on. But I think it's what you have to balance what you're comfortable with, because if you don't do it, then you have to imagine what the questions would be to you and what would your answer be for why you didn't. Why you didn't take steps to educate people before they got on in the form of a waiver, and why you didn't take steps to see if people otherwise were sick. I'm not telling you that there is an absolute right way or a wrong way to do it. What I'm telling you is on a scale of risk to you and your company, the more you do, the less risk you have. The less you do, the more risk you have. And simply at the end of the day becomes what you and your insurance carrier are comfortable with. Best practices, I think, and I think it will be easy for the bad guys to establish, best practices would at minimum require that passengers be relatively socially distanced, that passengers have on a mask, and that and then after that, I think it's up to how many bells and whistles you want to put on it. So that's how I would answer it. And I would, to the extent that I could get a release, I don't see that there's necessarily a problem getting a release from a passenger if you make that a term of carriage. I mean, they buy a ticket. You want to buy a ticket, you sign a release. You don't want to sign the release, don't buy a ticket. That's kind of the way I would approach it if I were in that business. Does that help, Bill? Hold on a minute, you're on mute. Oh, there you go.
that kind of that's the answer I expected. I'm just throwing it out there for everybody else to consider and think about. I'm coming from an angle here where I was a former school bus operator and motor coach operator, and the school buses, they're loading them up, taking them to school, and then they check the temperatures when they get off the bus.
Yeah.
They've already contaminated, if somebody's got it, it's already run, and it's going to be just a wildfire as it goes into the school. So I can see what you're saying, but it will be a challenge for people to get signatures and to get people to sign off on that and to take temperatures. That'll be a challenge. So I feel for everybody.
Yeah, I saw last night, my wife and I have at least once a year we try to go off to a resort in the Caribbean, either in Turks and Caicos or Grenada or somewhere. And I read last night that they are starting in those countries when you got a 14-day quarantine when you arrive before they let you onto the resort, and you have to contemporaneous at the expiration of your quarantine, you've got to produce a certificate saying that you are disease-free, and then they're still going to take your temperature and make you certify that you're well. That's what the folks at the beaches properties are doing down there. So it's everybody's trying to get as much of a shield in front of them as they possibly can.
So it turns into a 3-week vacation instead of one.
Right, exactly. So you just don't go. I mean, that's what the practice would be. If I could go for 3 weeks, I'd be doing something different right now.
Well, thank you very much.
Yes, Bill.
Any other questions for Steve? He is allowing me to record this, and he has said that I can share the PowerPoint presentation with you. So you still may have questions, and if you do, by all means, let's do it.
There are things, Linda, I made this comment the other day for a variety of reasons. Sometimes people don't like asking questions in an open forum, and that's perfectly fine. My phone number, my email's up. I'm happy to answer anybody's question that they may have, or it may just be something you think about after the presentation's over. I'm glad to lend a hand.
I will tell you, Steve is prompt in answering his emails. So
yes.
If you've got a question and want to email him, that's fine.
Hey, Steve, I've got a question. I don't know if you can hear me or not. This is Trey with Prevo. How are you?
I can hear you.
You can't hear me or can't hear me?
Can, C-A-Y, C-A-N.
Okay. I have an operator that has a different view on this, and basically he is on his website. He's showing what his cleaning policy is. He does have him do a waiver. He makes everybody, wash their hands when you get on the bus. He requires the masks. He does all this. In addition, he's also saying that he highly recommends that he puts together kits that cost him $5 that he's selling, but whoever does the charter has to buy it for everybody, not just for one person. It's a $10 charge per kit. And if his belief is if they say, well, that's too expensive, can't do that, they just switch the liability around from the bus company to the person taking the charter because they have not taken this extra step that he highly recommends. Do you see that as a value, or do you see that as a complete waste of time?
So you have to always be careful with stuff like that because so if he's offering that, that is some kind of recognition that he thinks that's necessary, right? Because if he's offering it, he must think it's necessary, but it's necessary, but not to the point where he's making it mandatory. I mean, if I were going to take a step like that, I would make it mandatory, because if you don't make it mandatory, then some people buy it, some people don't, and then somebody gets sick, and then you said there were things you could have done that I mean, the way the bad guys operate, the argument would be, well, wait a minute, you said there was something else that could have been done. You offered this. You didn't make everybody have it. Now my client got sick. If you'd made everybody do it, nobody gets sick. So I think things like that, you have to be really careful with those kind of things. And does it matter? I mean, again, see my earlier comment about there always, man, you can spend, I represent clients who have, 50 people working in the safety department. They got 25 lawyers on site. If you can think of a safety device, they got it. They probably invented it, and they still get the living hell suit out of them. So you can always spend more and do more. And when I hear you say that, what I can tell you without reservation is, no, he will not shift the liability by saying that the kit would have made the difference, because that would be a highly scientific opinion in the first place that I would be very surprised that he did. And secondly, I don't know how anybody could ever say that that not having the kit would be something that otherwise made the difference. And because the expectation for any patron would be that the bus, if you're going to let me on here, the bus should be safe without me having to buy the kit. And if I get sick once I'm on here, then it's still your problem, kit or no kit. So no, it will not operate to shift the liability in that circumstance. And I have to wonder, in the way you've described it, whether he's making more problems for himself than he's solving. Again, if you're going to say something like that and say this could help, then you probably ought to make it mandatory, right? Because if it can help, then by golly, you want it helping. And letting people in that environment without it would seem to me to be an acknowledgement that there are things that you could have done to help and you didn't make everybody do them. You follow what I'm saying? It would be like saying, well, I'm selling these $5 masks as you get on, and you wear them or not. But if you don't wear them and you get sick, it's your fault. Well, no, it doesn't work that way. So.
Okay, now I do have clarification on one thing. Sorry if you mentioned it, I got kicked off of Zoom because I'm driving to the country. But okay, so when you're talking about state law, we're doing a lot of interstate commerce, going state to state. Is it fall back on where the operator is, or were they actually based out of, or I mean, how does that work?
That's a great question. So the law typically around the country is the appropriate place for a lawsuit to be filed is the place where the event that caused the injury occurred. So good luck on that, right? Establishing which state you're in when the virus happened to jump up in your nose. So the first thing I would look at is I haven't seen recently, any contracts for carriage, or what your tickets say, and do your tickets provide a choice of venue on the ticket? That is, in the event someone makes a claim against you, that's where the claim would be made. Short of that, then you start, each state has its own analysis that you use for venue, including where the defendant has its principal place of business, where the defendant has a registered agent, where the wrong occurred, or in some instances, if nowhere else is appropriate, where the plaintiff resides. So it could be any number of places. Step number one, or first place to check, is what do your documents say when you issue somebody a ticket? And we'll note to self, if and to the extent that there was an opportunity to work a choice of law provision in there, I sure would, because there are some places, as everybody probably well knows, there are some places I don't mind being sued. There are other places that keep me up at night. So if I had opportunity to drive that in my contractual arrangements with my passengers, I would.
Okay, thanks.
Yep.
Steve, I've got a question. And you were just discussing something. Most of the people on this call do not sell individual tickets that we could print a liability label on the back, said, here's your ticket, the warning for such is on the back. Majority of people on here are charter operators, and there's one chartering party. They sign a charter for their group of up to 56 people, and they're responsible for payment if the bus is torn up, if you have a clause for excessive cleaning, or any other clause applies to that chartering party to be responsible for the other people on the bus. And that's kind of the way it's been. You go to the chartering party if somebody breaks the arm on a seat or such.
Yep.
We put out our first, 3 different versions trying to come up with a liability statement, working with people inside the industry. And the very first person I sent it to for a charter hacked out everything that would say the chartering party, you are signing for your chartering party, the traveling party, anything else. He scratched out and essentially said, kind of like the coach of a team says, I did not have COVID and I am accepting responsibility, but he would not accept responsibility for the rest of his players on there. Being that we're mostly charter, would we stand there and ask that all 50 people getting on board that bus sign a separate piece of paper so that each person is? That's one of our problems is the chartering party, it's hard enough to get them to sign a contract. Standing at the door asking everyone to sign a charter order before they can get on there, and then the coach says, we're going to be late getting to the game, this is stupid, why is everybody signing a charter, separate order? And then you've got to deal with that and say, well, because somebody told me I should. That's kind of a dilemma a lot of us would face if we were to say everybody on board that bus has to sign a waiver. We don't normally deal with each individual customer. We deal with one customer as the chartering party.
Alan, did you get that done in advance? Send it to the coach, have every player sign before they come and get on the bus, hand you the waivers?
Yeah, so Linda, go ahead and come on down to Richmond, my office. You can stay in the office right beside me. Yeah, so to answer your question and to pare it back kind of what Linda said, there's a substantial question in my mind that if a chartering company and a charterer, if you had a contract with them where you included language sufficient to constitute a waiver, whether that would even apply to the passengers anyway. Because imagine again how that's going to play out. So I have a deal with you where I come to you and say, I've got a group of 100 people and you give me the document to sign and I say, okay, I'm acknowledging all the risks, blah, blah, blah. Well, the people who actually are going to be the ones who are the claimants are going to say, I never saw that. I didn't know the risk. I wasn't aware that that was part of the deal. So I think you would have substantial trouble, even if they would agree to sign those documents. And with that being repetitive, I go back to say the same thing that I've probably said 3 times now. If I wanted to be bulletproof, every rear end that sat in a seat on that bus would sign that waiver. And I would do exactly what Linda said. I would try to get those things executed beforehand. Even printing it on the back of a ticket, which you mentioned a second ago, and I understand you guys don't do, that is only marginally effective. I mean, people do that. The Richmond Braves do that. The hockey team, all these professional sports teams put it on the back of it, but that won't operate to bar a claim. It just gives you some evidence that the patron was knowledgeable of some of the risks. These are specific risks. A general liability waiver, I don't think, is going to be what you need here. I think in this particular circumstance, because I've litigated enough waivers over the years to know, you need to be pretty daggone specific about what the risk is. And the risk here is that you're coming into an environment and there's a possibility that it could be the presence of virus or that somebody else could be sick. And that's a real possibility, guys. I mean, we see it in the news every day. I would wager right now on this call, however many of us there are, 35, 40 of us, that probably a third of us are asymptomatic COVID right now, because that's generally what statistics show in the United States. So any kind of operator of a commercial enterprise, particularly in the transportation, you're going to get people that got it. That's just the way it is. So if that's the case, I would tell you that the law of waivers typically states that the individual has to be specifically apprised of the risk. So even if the charter company or chartering company, the people chartering the bus, were prepared to sign it, I don't think that would operate to bar a claim.
Again, who would it be on if you were hauling a baseball team? Who would the responsibility fall to be sure that each one of these players has been contacted before it's time to load the bus? Because when they're loading the bus, they'll have no interest in this conversation. Are
you talking about adult, or are you talking about little league teams or minors?
College players.
Yeah, so I send the waiver to University of North Carolina at Chapel Hill and say, we're glad to charter with you guys. I need the players to sign this when they get on the bus. And let me again say, I recognize in the most distinct terms the logistical headache this is. I do. But without this, I think you're vulnerable, because if you don't have a waiver and somebody gets on one of your coaches and they get sick, then you become a potential source that they're going to look to. And that risk is compounded dramatically if you've had any incidents of disease at your business and or you're not following the guidelines that have otherwise been articulated by the various entities that we talked about earlier. So that's what I would tell you I would want to do. If it can't be done, it can't be done, but you're running a risk if you're not doing it.
Steve, there's one in the chat box. What about band members or football teams that are underage? The same may apply, but.
Boy, that's the great one. That's a great question. I mean, again, perfect world, I'd want a waiver executed by their parents before they got on. And again, I understand that some of these things must sound like, hey, go build me a pyramid tomorrow, and it may not be very, very feasible. But if and to the extent that you can make it feasible and the logistics can be worked out, I would work toward trying to get waivers, but for minors as well.
Thank you, Steve.
Ma'am.
Anyone else have a question for Steve? We've already kept him overtime.
Oh, it's okay.
But if you've got questions, we're going to stay here until you get answers, or you can contact him later.
Hey, Linda, this is Patricia.
Okay.
Hey, Patricia.
For Brenda Hay. There's a statement from Georgia, and I don't know if you can see this. I'm trying to put it in the thing here. This is something that they're requiring in Georgia if you're a small business to have, so that you can't be sued.
How about reading it to us, Patricia? We can't read it.
It says, under Georgia law, there is no liability for an injury or death of an individual entering these premises if such an injury or death results from the inherent risk of contracting COVID-19. You are assuming this risk by entering these premises. And this is something that the state of Georgia has put out that says, basically what it says, that if you get COVID, when you come onto the property, but I also have them in the buses, so that if you get COVID while you're on the buses, you're covered according to Georgia law.
Yeah, I think Georgia was in the list of the states that we had. There are a handful of states that have adopted those regulations, and if you happen to live in one of the blessed few that have, then the only particular piece of advice I've got to you relative to that is everywhere a patron might go, you need to have one of those. So,
Okay. But I know a lot of people don't realize that that sign, I mean, that notice is out there.
Yeah, and you need to make sure your protocol is good for making sure that they, in fact, get all the signs go up, and you need to make sure your protocol is good for somebody's checking to make sure the signs are still up on every, maybe it's in part of your daily checklist, but the signs are there. But anywhere people board, anywhere people come on your property, you need to make sure those signs go up and stay up.
Okay.
Patricia, would you please scan that and send it to me, and I'll be glad to send it out to all our operators.
Sure. Sure.
But to be clear, that will only have only bar claims in those states that have recognized statewide immunity.
Right. I was just going to send it to the Georgia operators.
Yeah, yeah.
It also has to be of a certain size. What you were holding up is not big enough. The lettering.
Yeah.
Then it looks on the sign. I mean, it looks on the
Well,
computer.
the letters have to be 1 inch high. The one I have is pretty huge. Once you print it out, the right size.
And I'll say that in the email, John.
Okay. That's the wording the news says that you have to have anyway.
I have a question. That statement that Brenda had, if we had that affixed to the side of the motor coach at the door entry, would that suffice as far as, taking care of the liability?
So
Actually getting a signature?
So the efficacy of the state immunity laws, just use your imagination of how the bad guys will try to get around that. And the first and most obvious way they try to get around it is that they'll say, excuse me, wherever you posted it wasn't visible to me and I couldn't see it. Right. So now we can all conjure up. I wouldn't put it under the bottom of the seats, for example, but I would put it in any place where somebody comes in or somebody walks out, particularly places where somebody walks in. And again, if I'm advising you, if I'm your company lawyer, what I tell you, probably not a bad thing to, if you're dealing with folks who are doing charters with you, to send to whoever the chartering company is. It's probably not a bad thing to make sure that if there are waiting rooms or places where you're picking people up, the more that you put it up without being terrifying, the better off you are, because that gets around that. That gets around the argument that they didn't see it and they didn't know about it.
This just comes to the point that Steve made earlier. Be aware of your state guidelines.
Yep.
This particular one was a Georgia state guideline. So, Scott, you're in Arkansas, so be sure to check your Arkansas.
Arkansas has adopted the liability law also.
Okay, great.
Yeah, and so usually those statutes, and I haven't seen the Arkansas statute, George, but they usually require it to be, they usually have some language that say it has to be posted in a, quote, conspicuous place. I mean, again, you can tell lawyers write these things because who knows what conspicuous really means. But so I'm doors. I mean, for example, here in our office, you can't see right now, but our exterior door on the way in, we've got the mask requirement, the temperature requirement. You got to certify this. Don't come in here if you're sick. We keep them up around the bathrooms. They're in the kitchen, any place where people could reasonably be expected to go.
That answer your question, Scott?
Yes, it did.
Okay, thanks. Anybody else have a question? All right. Steve, thank you so much.
You're so welcome.
Excellent presentation. I hope they all